and there's significant evidence indicating issues of fraud upon the court.
If you're going to make that accusation, counsel, you better bring it. I'm going to let you put the testimony on, but there are certain representations that she's made to this court that you may or may not be aware of.
A family torn apart by money, property, and broken promises walked into a Michigan courtroom expecting justice. What they got instead was a legal firestorm that nobody in that room saw coming. A brand new attorney stood up with fraud allegations, 1,000 pages of evidence, and a plan. But within minutes, the judge knew something the attorney didn't, and that secret was about to change everything. The case had been grinding through the courts for years. What began as a simple landlord-tenant dispute between relatives had slowly revealed itself to be something far more complicated. Mortgage disputes, ownership interest claims, allegations of insurance fraud, and a counterclaim that refused to die.
Date set some time ago for a non-jury trial. Are the parties ready to proceed?
Your Honor, may I approach the bench and go off the record briefly before I begin? I have a procedural issue.
A procedural issue?
Yes.
What? No, well, then I've got to have them up here.
Sure.
I guess, what is it?
Okay, so there is a counterclaim, which is what this is a separate full trial. There was already an order of eviction entered. I'm intending to move for summary disposition under C8 and C10.
The Sidonians, the plaintiffs, believed they had been wronged. Miss Finney, the defendant, believed the same about herself. Families suing each other over property is not uncommon. But the way this particular case collapsed on the morning of trial is the kind of thing that makes courtroom veterans stop and stare. The new attorney walked in confident. She had been recently retained, she explained to the judge, and had uncovered what she described as significant evidence of fraud on the court. She invoked MCR 2.1 Harzensteak Sieve 10, a Michigan court rule that allows a party to move for summary disposition when there is no genuine issue of material fact. In plain terms, she wanted the case thrown out before trial even began. She wanted time to brief the issue. She wanted an adjournment.
Well, why am I here on the date of trial? Was that?
Right. So the last motion that was filed, it was back in July. I appreciate that this is a long time coming. However, I'm recently retained, and there's about 1,000 pages worth of evidence. This is gone to mediation. There's conflicts in the facts, even in what was submitted during mediation, and there's significant evidence indicating issues of fraud upon the court and other issues regarding insurance fraud by the defendants. And it is my professional opinion that it does substantiate claims under MCR 2.116 C8 and C10.
The judge was not interested.
Well, the motion should have been brought before today. Okay. I mean, I don't know what particular issues you're talking about in terms of somebody committing fraud upon the court. And I'm just going to say this, if they were going to say this about the other side, if you're going to make that accusation, counsel, you better bring it. And it better be that, because if it's not, then I'm going to be exceedingly angry because I don't like people. I do not like people.
He had seen this case cycle through mediation, through settlement conferences, through years of delay. He had given both sides every opportunity to resolve their dispute before this moment. And now, on the actual morning of trial, with both parties present and ready to proceed, a new attorney was standing before him asking to reset the clock entirely. His response was controlled but unmistakable. You come in on the date of trial asking for an adjournment. That is not going to happen. This is the moment most people recognize from their own lives. Think about the colleague who misses every deadline but always has a reason. The manager who moves goalposts the moment accountability arrives. The fraud allegation was real enough that it deserved to be heard. But the timing was a problem that no amount of evidence could fix. Courts run on procedure. Procedure exists because without it, litigation never ends.
Okay.
Coming in on the date of trial, asking for an adjournment of these proceedings is not going to happen.
Okay.
So you guys either can try to resolve this thing, or we're going to try it.
Okay. Fair enough. Then I would request a brief recess to please speak to the defendants.
Okay.
The judge sent both parties to the jury deliberation room to see if they could reach a settlement.
It wasn't entirely productive, Your Honor. So we have, back from 2021, a consent order for conditional dismissal. There was an eviction order entered after that time against the defendants. Again, It's my position that the counterclaim needs to be dismissed, and the fact that there was an eviction order entered. At this time, this can't be a cognizable claim before the court.
When they returned, the defendant's family made a stunning claim.
My understanding is the parties have had further discussions.
When we came back in, she asked us to step out in the hallway. And when we stepped out in the hallway, she proceeded to tell us that pretty much if we don't take the $5,200 in escrow all the way today, that she's going to file a lawsuit against us in a different court, that you won't be our judge, and we over $25,000. So no money matter. She didn't want to talk about the money matters again. So she said escrow only. So I just leave it in your hands, Your Honor. I don't know what to do anymore.
It's completely misconstruing what I said. And we shouldn't even be talking about settlement matters, but I made a valid settlement.
Counselor, if you don't want to talk about it, don't talk about it.
Yeah.
It's not going to make a difference to me.
Right.
They said that in the hallway. The attorney told them that if they didn't accept $5,200 today, she would file a new lawsuit in a different court, one where this judge would have no authority, for over $25,000.
And have you asked for removal?
I would request a removal, Your Honor.
I'm not removing this case.
Okay.
I think it was, and you coming late to the game, I think I explained to the Sidonis I don't have jurisdiction over the title.
Okay.
I also explained to them that my jurisdictional limit was $25,000. I explained that very clearly. I think I explained it actually to both sides during the couple of final settlement conferences that we had. I don't know why it's being raised. They have elected throughout these number of years to have the case remain here. So at this point, I'm not removing it. Anything
The
else?
attorney denied misrepresenting anything. She said she had made a valid settlement offer. The judge heard both versions.
I mean, I'm just going to say this. I mean, we go back there and talk. Your client, I'm going to let you put the testimony on, but there are certain representations that she's made to this court that you may or may not be aware of, because you got caught with one. I'm not saying caught in the sense of whatever, of a statement that she made, which is absolutely contrary to what she said before.
And then he said something that stopped the entire courtroom cold.
Okay.
All right. Are we ready to try this?
To be let off the case at this time?
You're looking to withdraw?
Yes. I can't reasonably represent her if I'm going to misconstrue the facts.
Well, it's not an issue of you misconstruing the facts. I'm just telling you that there have been certain representations made on the record, which I will tell you were different than what was said today. And I will tell you, counsel, I can tell by your reaction that you did not know that.
He told the attorney quietly and directly that there were certain representations her client had made to this court, representations that directly contradicted what had been said that very morning. He looked at the attorney's face, and he said, "I can tell by your reaction that you did not know that." She didn't. This is the single most devastating thing that can happen to a practicing attorney. Not losing emotion, not having evidence excluded, discovering in real time in open court with the judge watching your face that your own client has been lying to you. Every attorney who walks into a courtroom stakes their professional credibility on what their client tells them. When that foundation turns out to be built on misrepresentation, there is nothing left to stand on. The attorney did the only thing she could do. She asked to withdraw from the case entirely.
So if you are going to move to withdraw, I'm going to step off, and you probably need to have a detailed conversation with your client about that. The court's going to stand in recess. Everybody can remain seated.
Now consider what this means for everyday people. How many times have you defended someone, a friend, a coworker, a family member, only to find out they weren't telling you the whole story? You put your reputation on the line for them. You argued their case, and then the truth arrived and you were left standing there exposed. That is exactly what happened to this attorney inside a court of law. The difference is that for her, the consequences were professional and permanent. Under Michigan court rules, an attorney cannot continue to represent a client when that representation would require them to take positions they know to be false or misleading. This is not optional. It is an ethical obligation. The withdrawal request was not an escape. It was, in a deeply uncomfortable way, the most ethical act she could have performed in that moment. Here is the question every viewer has to wrestle with: should the attorney be blamed for what her client did, or does the client bear sole responsibility for putting her lawyer in an impossible position? Drop your answer in the comments because people are genuinely divided on this, and the answer reveals something important about how you think justice should work. The judge granted the withdrawal, but not before a resolution was reached. The parties settled for $10,000 in favor of the Sidonians.
Parties have come to a resolution. I'll state it on the record and then ask for the concurrence that that is the agreement. Parties have agreed to a full and final settlement of all claims that could have been raised in this case or have been raised in the amount of $10,000. That will be in favor of the Sidonians. That $10,000, the amount of $5,263.17 will be released to the defendants from court escrow. The remaining amount of $4,736.83 will be paid by Ms. Finney to the Sidonians in monthly payments over a 2-year period. When did she wish to begin those payments?
Next month.
Should the defendant miss a payment, default on the payments, an additional amount of $5,000 will be added to the $10,000 figure. The Sidonians would then be entitled to a judgment in that amount, less any payments, which is inclusive of the escrow that have been made.
A portion was to be released from court escrow immediately. The remainder would be paid by Ms. Finney in monthly installments over 2 years. If she defaulted, an additional $5,000 penalty would be added automatically. The judge read the terms onto the record, confirmed that both parties understood and agreed, and closed the matter.
The oral motion of counsel to withdraw once the order has been prepared, I will grant that, so that after that, the order is signed, she will have no further obligation to this case unless she undertakes it in some other way. That's the court's full understanding of the agreement of the parties. I'll start with you, Ms. Finney. Is that your understanding?
Yes, sir.
Do you have any questions whatsoever regarding that? And I will ask this because of what occurred. You are satisfied with the efforts of your attorney in representing you today in this matter?
Yes.
All right, great. To the Sidonians. Mrs. Sidoni, is that your understanding of the agreement?
Yes, sir.
Do you have any questions regarding that agreement? And you are satisfied with that agreement? I will await the order, then I will sign it. I will thank all of you for working this out today. It has been a long haul, but I think it certainly has resolved in the best
Justice
interest.
arrived, but only partially. The client who had made contradictory statements to the court walked away with a payment plan rather than a perjury charge. The attorney who had her credibility put at risk by her own client was freed from the case with no formal sanction. The system resolved the dispute. It did not fully reckon with the conduct that nearly derailed it. And that gap between resolution and accountability is where most people's frustration quietly lives. What this case teaches is not complicated. Truth has a very specific shelf life inside a courtroom. You can control what you say. You cannot control what was already on the record before you walked in. The judge in this case had read everything. He remembered everything. And the moment the story changed, he knew. The courtroom is one of the few places left where your past words are always present in the room with you. If there is a case or a courtroom moment you want us to break down next, drop it in the comments below, subscribe, and share this video, because an informed public is the only real check on a system that would rather you stayed confused.